Testing? Testing?
So if you, yeah, so you're just gonna press it. Now it's off. Press it again. And if you just wanna come up a little bit closer to it.
Okay. So you want me up here now?
Not right now, but we'll have
Okay.
we'll have.
But this is
the
where you
commission-
want me eventually?
Yes,
Got
I'll
it.
eventually.
Testing, testing.
Great. So we're when the commissioner's done, then we'll have the rest of you.
Hey, Lloyd. That's okay. We can explain to you later. Do you have the? Commissioner, how you doing?
Well, you know, when the weather acts up, it gets a little iffy out there. So, but you know, I got a strong deputy. That's why you have number two.
Yes, you are set to go.
Hola, Mr. Chairman. I'm banking some early time.
I was gonna say.
Kim, I hope you're keeping notes there.
¿Cómo se va?
Muy bien.
Good. I don't know whether, have you got anybody? Well, Lloyd's here. How are you doing?
surprise.
I was sort of waiting for one of ours to show up, but we'll go ahead.
Still early. You did?
No what?
Pictures during the hearing.
Not, you can take pictures, you just can't be right in the well. You have to be off to the side. Yes, yes.
There you go. All right, we answered that.
Hello, Lloyd. Good. What are you up to for vacation? Is that new for you? I know you did. Yeah, I know you did. Congratulations. Oh, gracious.
The mic is on.
Welcome to the committee. Good afternoon. It's our fourth hearing in our series on securing the future of Social Security disability. Today we'll focus on how Social Security disability claims are appealed and whether the process works as well as claimants and taxpayers have a right to expect. In earlier hearings, we have highlighted the explosive growth of the program at a time when a number of workers paying into the system has increased nearly 70%. Between 1970 and 2011, the number of people receiving disability benefits has increased by over 300%, from 2.6 million people to 10.4 million. By 2021, the number of beneficiaries will exceed 12 million. By then, total benefits paid will reach 196 billion. That's 52% increase over the 129 billion paid in benefits over the last year. The size of the overall workforce, more women in the workforce, aging of the baby boomers into their disability-prone years, and relaxed eligibility requirements have all contributed. The continued growth is putting a real strain on Social Security disability. As we heard from public trustees at our hearing last week, without congressional action, the Disability Insurance Trust Fund will only be able to pay 79% of benefits beginning 2016, just 4 years away. Path we are on is unsustainable. Further disability applications have spiked even higher than expected due to recession and the snail-pace recovery, reaching an unprecedented 3.3 million last year. Resulting appeals have further increased pressure on appeals process that's struggling to keep up. Americans are also paying more for Social Security to administer its programs. Costs are up 68% compared to 10 years ago, and last year administering disability programs cost nearly $7 billion, two-thirds of Social Security's operating budget of $11 billion. Turning to the appeals process, those who have initial claims for benefits are denied the right to appeal through 4 levels of appeal: reconsideration by the state agency, hearing by an administrative law judge, review by the appeals council, and federal court review. An open record allows claimants to add new evidence to the file through every step of the appeals process. Even though about 79% of all awards are made at the State Disability Determination Services, according to Social Security, last year about 860,000 claimants filed appeals to appear before an administrative law judge. Americans are rightly paying attention to the hearing process, even though claimants are waiting close to a year on average for a decision. Almost 12% of ALJs decide 200 or fewer cases per year. This is in spite of the fact that Social Security has asked these judges to do 500 to 700 cases annually. Also, the decisions of so-called outlier judges who deny or allow most of the cases they hear can't be questioned. The claimants' representatives are part of $1 billion plus a year industry encouraging appeals and making a living by collecting their fees from benefits awarded their clients. Further, when cases are appealed, the courts have taken it upon themselves to reinterpret what Social Security Act requires, resulting in varying policies applied in different parts of the country in what is supposed to be a national program. Now, I know some of my colleagues believe that all these problems can be solved if we'll just give Social Security more money. In fact, over the last 6 years, funds have been poured into the hearing level for ALJ hiring, staff hiring, new offices, and technology fixes. And while service has improved, it seems success is always just a little further down the road and depends on even more resources. Yet in these tough fiscal times, Social Security's done well. Its operating budget increased this year compared to last year, despite a 1.5% decrease in the discretionary spending cap. In fact, Social Security is subject to the same long-term domestic spending limit enacted in the Budget Control Act. That same bill authorized an additional $11 billion over the budget caps for Social Security to increase continuing eligibility reviews in its disability programs. There were 95 Democrats, including the minority leader and the ranking member of the full committee, who supported the bill. Understanding why the appeals process works the way it does is just as important as making sure that those who deserve benefits receive them. So let's ask hard questions to determine if we can fundamentally do better. Why do over 20% of the claimants who are ultimately awarded benefits have to wait at least a year for a decision? How can benefits be awarded to those who qualify as soon as the process is done? And why does Social Security channel so many of its resources to the most expensive step in the appeals process, even when the cost to process a case before an ALJ is more than twice what it costs a state agency to make the same decision? Why aren't claimants' attorneys doing a better job of submitting all the evidence earlier? Should representatives be able to encourage a client who has waited months for a hearing to wait even longer so they'll get a judge who is more likely to award them benefits? And why do some judges hold hearings for 10 minutes and others for 2 hours? And some of them don't even hold them. Today we have a number of outstanding witnesses before us, including the Commissioner, who has done more to engage the attention of Congress on a wide array of needed improvements to the appeals process than any other Commissioner in decades. So let's take a good look at all sides of this process and find out what we can do better for everyone. I want to thank you again for being here, and I now recognize the Ranking Member, Mr. Bassar, for his opening remarks.
Mr. Chairman, thank you very much, and thanks for calling this fourth hearing in our series focusing on Social Security's disability insurance program. Before we delve into the details of Social Security's appeal process, I want to first take a step back and look at the big picture. Social Security is vital to millions of severely disabled American workers and their families. Benefits are modest, averaging just over $13,000 a year, or about $35 a day for a typical disabled worker. These benefits, however, are a lifeline for the more than half of the disability insurance recipients, the DI recipients, who would live in poverty without Social Security. DI recipients are only a small fraction of the most vulnerable Americans with disabilities and serious illness. The eligibility criteria to qualify for Social Security disability are tough. Social Security's appeals process helps ensure that all workers who are eligible and have earned DI receive it. The disability application process begins with the State Disability Determination Service, or DDS, which makes a decision on the application. The DDS is an important part of the disability determination process, but alone it is not always sufficient to ensure that individuals get the disability benefits that they've earned. The decision about whether an individual is disabled enough to qualify for benefits can be a difficult one. In addition, there can be complicating factors in individual cases. For example, some people with disabilities do not have access to medical care, and therefore they do not have the medical records needed to prove their case. Recognizing these realities and challenges, Congress and the Social Security Administration created an appeals process to help ensure that everyone who meets the eligibility requirements gets the benefits that they have earned. The current appeals process has a number of strengths, and of course, there is always room for improvement. It is designed to be fair and accessible. It's non-adversarial, so judges can focus on fact-finding and applying the law. It's impartial, because independent judges take a fresh look at the case and their decisions are not based on meeting certain allowances or denial rates. And it's face-to-face. And that may be the first time that a person who is claiming disability may see an evaluator face-to-face and actually be able to talk to that particular evaluator. We are going to hear a number of ideas today about how to improve the appeals process. I'll be evaluating those different ideas using a very simple standard. Will it ensure that Americans who are eligible for benefits are able to get them, or will it create procedural hurdles or other obstacles that would deny access to benefits that they have otherwise earned? Budget decisions by Congress also affect whether Social Security is fair to hardworking Americans and their families. We have seen how the Social Security Administration can reduce waiting times when Congress provides adequate funding for SSA to process claims quickly and accurately. In 2008, waiting times for appeals hearings were at an all-time high of 535 days of waiting. In fiscal year 2009 and 2010, Congress, then under Democratic control, provided SSA with a total of $2.2 billion worth of new resources to reduce backlogs, and waiting times dropped to 340 days. Still a lot, but compared to 535 days, far better. This current Congress has cut Social Security Administration's budget in 2011 and 2012. With less funding and fewer employees, it is inevitable that hardworking Americans will have to wait longer to receive the benefits that they have earned. We are already starting to see the negative effects of these budget cuts. Waiting times for initial benefit decisions are on the rise and are likely to go from 111 days to over 130 days by the end of this year. Waiting times for appeals hearings have crept up from the 340 days in October 2011 to the current wait time of 350 days. So once again, we're heading in the wrong direction when it comes to Americans getting the benefits they've earned. SSA is now facing an even bigger cut under what's called sequestration, the automatic cut scheduled by the Budget Control Act passed last year. Although Social Security benefits are protected under sequestration, if Congress doesn't act soon, SSA's operating budget will be cut by more than $1 billion on January 2nd. Even though 100% of the cost of administering Social Security is paid for by workers through their Social Security taxes that they pay and put into the trust fund. A $1 billion cut to SSA would translate into 40 days where SSA offices would be closed over the course of a year. No one should be surprised if these harsh cuts to SSA's budget damage Social Security's well-earned reputation and undercut SSA's ability to continue to capably serve Americans as it has for over 77 years. Mr. Chairman, the most immediate threat to Social Security disability appeals process is the budget cuts that would prevent appeals from being heard at all. I hope we can work together to make sure Americans get the Social Security benefits that they have earned and deserve. And I today look forward to our witnesses' comments on how the appeals process itself can be improved. And with that, I yield back.
Thank you. As is customary, any member is welcome to submit a statement for the record. And before we move to our testimony, I want to remind our witness to please limit your oral statement to 5 minutes. However, without objection, all written testimony will be made part of the hearing record. We have two panels today. The first one is a single witness, Commissioner of Social Security, Michael J. Astrew. Welcome, Commissioner. You may proceed.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member Becerra, members of the subcommittee. During my first week as Commissioner in February 2007, I testified before this subcommittee about the hearings backlog. To put it mildly, you were extremely upset about delays your constituents faced while waiting for a disability decision. The backlogs had steadily risen throughout the decade, and the plan I inherited to fix those backlogs was draining resources and making the problem worse. At that time, over 63,000 people had been waiting over 1,000 days for their hearing, Some of them were waiting as long as 1,400 days. We were failing the public. Rather than devise yet another signature initiative that would not stand the test of time, we went back to the basics. We developed an operational plan that focused on the nitty-gritty work of truly managing the unprecedented hearings workload. We made hundreds of incremental changes, using video more widely, improving information technology, simplifying regulations, standardizing business processes, and establishing ALJ productivity expectations, to name just a few. We also committed the resources our employees needed to get this work done and done right. This plan has worked. Average processing time, which stood at 532 days in August 2008, steadily declined for more than 3 years, reaching its lowest point of 340 days in October 2011. In 2007, filing rates had been stable for some time, so looking at the number of pending cases was a reasonable, if imperfect, method to measure progress. As the recession hit and the number of requests for a hearing dramatically increased, we steadily improved our performance when measured by average processing time, the best metric for tracking progress, particularly in times when filings are changing rapidly. Like a line in a store, the customer's experience depends not on how many other people are waiting, but on how quickly we help them. In August 2008, people waited an average of 532 days. Today, that's about 350 days. Average processing times also became more uniform around the country. The most dramatic improvements have occurred in the most backlogged offices. Average processing time in Atlanta North dropped from 900 days to 351 days. Oak Park, Michigan improved from 764 days to 254 days. Columbus, Ohio went from 881 days to 351 days. Currently, no office in the country has an average processing time greater than 475 days. 15 offices have hit our ultimate goal of 270 days or less, and many others are getting close. These numbers are even more impressive because we have given priority to the oldest cases, which are generally the most complex and time-consuming. 5 years ago, we defined an aged case as one waiting over 1,000 days for a decision. Through the steady work of our employees, we now define an aged case as one taking over 725 days to complete. Next fiscal year, our management goal is to raise the bar on ourselves again by focusing on completing all cases over 675 days. This emphasis on eliminating aged cases increases average processing times, so we also look ahead to see how long people in the queue have been waiting for a hearing. Today, that number is just 208 days, and we were hopeful that figure will drop again next year. By contrast, the average wait was 324 days at the beginning of FY 2007. Despite our employees' hard work, the progress in addressing our hearings backlog is happening more slowly than the public deserves. If we are not adequately funded and we cannot timely hire enough qualified ALJs and support staff, our progress will erode. We've already had to make decisions that have slowed progress, such as canceling our plans to open 8 new hearing offices in Alabama, California, Indiana, Michigan, Minnesota, Montana, New York, and Texas. Amid huge economic and budgetary unpredictability, we have stayed focused on eliminating the causes of your moral outrage in 2007. Now we need Congress to enact the President's budget request so that we can meet our commitments to the American public. Thank you, and I'll be happy to answer any questions you may have.
Thank you, sir. Appreciate your testimony. And since this may be your last meeting with us, we thank you for your service to Social Security and to the government. And
Thank you very much. I've been actually waxing a little sentimental. I realize it's been 27 years since I first testified before the Ways and Means Committee, and it's a real privilege to work with an institution that touches the American public in so many ways, from taxes to health care to Social Security to trade.
thank you. As is customary for each round of questions, I'll limit my time to 5 minutes and ask my colleagues to also limit theirs. Questioning to 5 minutes as well. Options that would allow Social Security to better manage the hearing process. Commissioner, protections are included in the Administrative Procedures Act to ensure that administrative law judges are able to make decisions without agency interference. In our next panel, Judge Fry testifies that using an APA official protects the claimant's constitutional right to due process, but Professor Lubbers from our next panel says the Supreme Court has not agreed with this rationale in the case for hearing of benefits. Also, Professor Lubbers testifies that ALJs are not required by Social Security law. You have said that ALJ decisional independence places limits on your ability to manage the performance of judges, even when some judges process far fewer or far more cases than peers, or award or deny for far more or fewer cases than their peers. And you've also discussed your challenges with the Office of Personnel Management, providing you with qualified ALJ candidates, including the fact that they don't do background checks, even for lifetime appointments. And you've also told us that disciplinary action against an ALJ takes up to 2 years to process, while the judge can stay home with full pay and benefits. Given all this, why do we need ALJs at all to do the work?
I was trying to figure out what the question was going to be. I think that question's been asked several times before, and I know we got Professor Lubbers' testimony right before the hearing, and so I did take a quick look at the statute. The general authorizing language for conductive hearings doesn't specify administrative law judges. That didn't stop me from trying to look at the statute. And I think there's some, we'll kick back to you on the record, but it looks to me, and I'll be interested in what my friend Mr. Lubbers and what Judge Fry have to say, it does look to me in other places in the statute that Congress has assumed that ALJs are now part of the process, and I think we'll have to go back and give you a formal opinion for the record on that. But I'm looking specifically at 42 USC 423H as one example where Congress seems to assume that they are in fact embedded in the process at this point.
Yeah, I don't think it's mandatory at all under congressional edict. Professor Pearson, our next panel, recommends eliminating the role of ALJs as decision makers, or at least amending the law to make it clear that Social Security has the power to evaluate the performance of judges and take needed action. And in my opinion, you don't have that. What are the pros and cons of changing the law to make clear that Social Security has the power to hire their own judges and evaluate their performance?
Well, I certainly think that when this committee was regularly reviewing the performance of the Office of Personnel Management regarding the ALJ process, so that was very constructive from my point of view. We saw real progress that we had not seen in the previous decade. Since the last time that we testified together, I think that it has not that change has disappeared. And so I do think commissioners have been testifying since 1977 before this committee about difficulties with OPM on the administrative law judge process. I think that you need to look at this with some intensity and say, has that agency consistently and timely provided quality judges, not only for us, but for all federal agencies? And I think that the definition of qualified that they use is totally inappropriate, because in order to be a judge, there's a high level of professional accomplishment and a high level of moral character that should be required. And when we say well qualified, we're using a different standard from what the Office of Personnel Management has been using. And I think the fact that we've made so much progress in the last 5 years comes from using that higher standard. Something that I think you should be pleased about, Mr. Johnson, because I know it's been one of your concerns, is the number of outliers has been reduced dramatically in the last 5 years. If you look, you've used the 85% standard. We've gone from almost 20% to about 5% that are allowing more than 85% of those cases. And that's largely the influence of hiring right. A judge who is arrogant, who behaves badly, is also not going to apply the statute that you have enacted faithfully. And so I think the emphasis on quality in the judges is important. And I have to say, over decades, I don't think the standard at the Office of Personnel Management has been high enough.
Well, I think they have no requirements for judges, and we need to get some in. I'm going to ask one more question. Last December, the Wall Street Journal published an article entitled "Two Lawyers Strike Gold in U.S. Disability System." The article is about a law firm of Binder & Binder, which collected $88 million in fees, all paid from claimants' past due benefits. In their testimony, Professors Pierce and Lubbers of our next panel refer to the incentive representatives may have had to drag out cases since the fees are a percentage of the client's past due benefits. Is it true that the longer it takes to get a decision, the higher the representative's fee will be?
Yes, it is, Mr. Chairman.
And you don't agree with that, do you?
Well, I think it's been a concern for many years. I think it was 1987 when this subcommittee took up the attorney fee matter. I was part of the team on the other side that raised some concerns about the economic incentives of the current system. So it's clearly a risk. I think most of the attorneys and representatives most of the time are very honorable about not abusing the system, but the incentive is there, and I think we do see a significant minority of representatives abusing the system from time to time, both in this and manipulation of assignment of judges.
Part of the problem is
things,
their
right?
point for life. You can't get rid of them. Mr. Becerra, you're recognized for 5 minutes.
Chairman, thank you. Commissioner, thank you for being here, and always thank you for your years of service to the people of this country. Let me make sure, I want to be clear on something. The FICA tax, which everyone pays when they get their paycheck every week or month, they see a deduction for FICA. That's the money that goes into Social Security and Medicare, the FICA tax that we see, the contribution that workers make and have been making for 77 years to the Social Security Trust Fund and the Social Security system. That FICA tax money, which is used to cover Social Security, covers benefits and also your operating expenses.
Yes, there's a specific appropriation. We can't just tap that money. There's a specific appropriation that's then drawn from the trust funds, right. Yes.
So Congress sends you money, it's appropriated money, and ultimately Congress gets reimbursed by the trust fund for the money it's given to you to operate.
I'm not sure I fully follow the question, Mr. President.
So the money for you to pay your employees to cover all your overhead, your lights, your computers, you don't get extracted directly from the trust fund. The trust fund has the money. You get an appropriated amount. Then Congress makes sure that the trust fund covers what the appropriation was.
Yes, I think that's essentially
so
right.
Essentially, workers, when they make that tax contribution, the FICA tax contribution, they're paying for the cost not just of the benefits for today's Americans who are retired and getting a pension benefit through Social Security, or who are disabled and getting a benefit. Those workers, through their FICA taxes, are also paying for the cost of administering all the Social Security's program.
Yes, that's right.
Okay. And yet we're finding that Congress, and I think so you said something in your testimony, that Congress so far this year you're going to be getting a lower amount than you requested in your budget. I think you said something in your testimony, I was struck by it, something over the past 2 years, the gap between what Social Security Administration needs to serve the American public and the resources actually appropriated by Congress was the biggest it had been in 20 years. So SSA has been more than $2 billion short of what it needed to process all claims promptly, reduce wait times for disability cases, answer its phones, and perform all the other work it does to serve the American public. So no matter how hard your employees at SSA work or how well you prioritize, eventually Americans are going to be paying the price for the shortchanging of your agency when it comes to the budgetary needs that you have. And so when you mention the wait times for these appeals hearings, or the wait times to have your initial application processed, that's the consequence of not having the resources to get the work done.
Yeah, and let me stress that I think that we're different from most other federal agencies in that because of demographics and because of the recession, our workloads have gone up dramatically. You know, we're not like certain other agencies that can simply prioritize things differently. When people come and apply for benefits, we have to process those claims. We have to process the appeals. We're taking in more than 1 million applications more each year between disability and retirement than what we had originally projected, driven by the recession.
Right.
And I think if, in fact, if this recession had been less deep and less long, would have made a huge impact on the hearings backlog. I think we'd be at the 270 by now if the recession hadn't been so deep and long.
So the recession making the problem deeper and more people are applying, but you're getting less money to try to operate and provide those services. My understanding is that you've already had to close a case processing center and that you've had to cancel the opening of 8 new hearing offices and a telephone service center that could have served quite a few of these folks who are applying for services and benefits. Let me ask one other question with regard to your ALJ policy, the policy for these judges. And thank you, by the way, for your commitment to review some of the policy changes that you are trying to move forward with. And in this case, with regard to the disclosure of the names of these judges at the hearing level in advance of the hearing, we had conversation about that. Can you, real quickly, my time's going to expire soon, just give me a sense of the status of your review? And when do you expect to take steps to revise this policy in light of the concerns that have been raised about the perhaps overbroad nature of the policy itself and how it might be detrimental to those applicants for disability benefits?
Right. We view the policy, I think, and have from the get-go really as a stopgap until we come up with a broader, more effective solution. I think this is an issue that caught us a little bit off guard. I don't think until our management information got better, we didn't realize how much the system was being manipulated and in how many ways and at what cost to the integrity of the system. We have a team working on this. I've met with the team. We're meeting again second week in July. I think on the initial reaction, we don't think that the good news is we don't think that we need to come to Congress for statutory changes. We think that we can address this with a pretty complicated mix of administrative initiatives and regulatory initiatives. What the exact mix of those are and whether the administrative things that we could do more quickly make sense without some of the regulatory initiatives, we're not sure yet. So we have, to say we have a plan at the moment would be overstated. I think we have more of a plan to have a plan, but I think we'll have a better sense late July, early August. But if we have to go through the rulemaking process on key parts of it, that will mean it will be a little slow. It's a particularly difficult time of the year to get things through the rulemaking process, but we're working on it. We'll do the best we can as fast as we can.
Thank you. Thank you, Mr. Chairman.
Thank you. Mr. Marchant, you're recognized.
Thank you, Mr. Chairman. Welcome, Commissioner.
Thank you.
Thank you for your visit last week. We had a good visit.
It was indeed.
I appreciate it. State disability determinations award roughly 79% of all awards at a cost of about 1/3 of what it costs a judge to process a request for hearing. Beyond compassionate allowances and quick determination screening that you already have in place, what can be done, what more can be done to resolve the deserving claims at the state level?
I think that's a great question. I think, and very timely. We just issued a press release, I believe, on Monday on what I think is one of the most significant things will change the basic paradigm of how we do business. An enormous amount of our administrative budget is spent chasing down, collecting, and organizing stray, generally paper medical records. And we often don't know for sure that we have them all. So it's not only a big source of cost and delay, but also of inaccurate decisions. When we move to a world where most Americans have a complete electronic medical record, it will enormously improve what we're doing. We've done some small pilots with a few of the providers and insurers who are already there. what we've started now with Kaiser Permanente is our first large-scale effort in this area, and I think this is going to be tremendously important. And it's going to take probably 3 to 5 years to work out the arrangements, and the private sector is moving slowly for a variety of reasons. But we're going to get there, and you'll see 3 to 5 years from now a dramatic improvement, I think, in our cost, our speed, and our quality when we can essentially push a button and in most cases get a complete medical record electronically.
And during the entire process, the medical record stays open throughout the entire
Yes,
appeals
that's right.
process. So is there any merit to closing the records at some point so that somebody that's making the decision can actually make a decision without having to the next day take in new information and make another decision, then take in new information? Is there a fair process where you close the case, the hearings?
Well, we thought so, and in the New England region, we still have closure of the record before the ALJ 5 days before the hearing. To use the phrase from the testimony, to put it mildly, the subcommittee took umbrage when we tried to propose that in notice and comment rulemaking and made it extremely difficult for the agency to pursue that. But we proposed that and had to withdraw that in 2008, I believe.
Okay. And the last question I have for you, and I come from a state legislative background, and I believe that the local state determinations are probably the most efficient ones. But with the rise of disability claims that we've seen in the last few years, and with the state having an integral part of the qualification for unemployment benefits, and the state also having an escalating Medicaid expense, have you noticed, or is there a trend line where states are trying to shift people from unemployment into disability, and then from disability, where they stay on disability, I think it's 2 years, and then they go from Medicaid to Medicare, and the state then basically can shift them from the Medicaid element where they're putting a match in over into the Medicare element? And do you see states that are developing a philosophy towards that?
Anecdotally, we think the answer to that question is yes, to some extent. Maybe not so much unemployment as TANF. We actually brought in an academic expert a few years ago to help us try to track and document that. It's been very difficult to provide hard evidence of that, but we do think that there are states that, for their own budget reasons, are putting up barriers to state benefits and requiring an application to us for disability, even though there's no reason to believe that the person is disabled. So we do see some of that. How big a factor that is, I don't think that we know. I think it's relatively small, but it is an abuse that exists, and we wish that states would not do that.
Thank you, Mr. Chairman.
Thank you, Mr. Brady, you're recognized.
Thank you for the discussion, Representative Martian, about the need to make these determinations as early as possible. But Commissioner, thank you for your service and leadership of the agency, and wish you well.
Thank you.
Going forward. And you have a great servant's heart, so thanks for what you're doing.
Thank you.
2 questions. One dealing with fraud, both at the front end and those applying for it, and on the back end, which is those who are capable of working but defraud us in the process in the continuing disability reviews. What's the status of our efforts to fight fraud within disability, and what more can we do, again, to capture the money we really need for people who are truly disabled?
Sure. So I know that I and other commissioners have been through this in the past, and I know that there have been efforts to come up with a mechanism that would allow us to do this that hasn't been successful yet. But the single most important thing is timely review of existing beneficiaries. We all know that there's an enormous payback to the taxpayer
There is.
from timely continuing disability reviews. Those had dropped dramatically in the years before I got here. They've gone up dramatically, but remember, I don't set them. I come and I plead and I beg here in Congress, and I've been somewhat successful. So the number has gone up pretty significantly and substantially, but it's not where it should be. And in this past year, we had to reverse. We were geared up. We thought both committees and appropriations passed 582,000, and then at the last minute, the bill passed, and the number was 435. And we had to not only not hit a more appropriate level, we had to reallocate a lot of resources halfway through the fiscal year. Coming up with a mechanism so that the agency has the resources to do that work is, I think, tremendously important. I think some of the new technologies that we've put in place have very high returns as well. We have ways now of checking assets with banks. The early returns were a 20-to-1 return. We don't think we're going to see that on an ongoing basis. We don't know yet what the return is, but the return on that is very high. We're trying to come up with a similar system for other types of assets, real estate assets and things like that.
But
Also, I put in a pitch for the Inspector General. For budget reasons, the number of CDI units, which are these joint SSA, IG, local law enforcement units, which have been very successful, I think, on the whole, the number of those that we have are going down rather than up, and I think that's a penny wise.
But how about at the front end? One, thank you for that comment on time reviews. How about on the front end into the process, not just those who are hiding assets, but those in providers who were enabling those to try to defraud the system with medical disabilities? What percentage of applicants are we now identifying through the process on the front end,
Right.
Who are attempting to defraud the system?
It's relatively small, but the disability examiners are actually quite good about being alert on these things, and they do a significant number of referrals. Some of our administrative law judges have been very sharp about this too. One of the more spectacular ones that we're working on now came because of a very alert ALJ. I would say if you're going to focus on one thing, I think that the treating physician rule historically, relied on a different paradigm. There was a time when we all had a Marcus Welby as a personal physician, and that's not true anymore. And in fact, we're increasingly seeing physicians who are essentially extensions of the lawyers doing the representation. I mean, often, sometimes physically housed within those complexes. I don't know that those kinds of physicians should be given the same deference that the court interpretations of your statute require us to do. And the courts are also all over the place in terms of treating physician. I know there's always a lot of skepticism about the agency's view on this, so what I would say to you is get some good outside advice on that. At least reconcile the conflicting court interpretations so that we do this uniformly and fairly around the country. But I think it's also a fair question to ask, given how the world has changed, is the rule that struck people as appropriate 30, 40 years ago still appropriate today?
Are there significant resources, and are there, I'm sorry, my time is up, on the insignificant punishment for either physicians who are complicit or claimants reps who are complicit? Do you think we have what's needed in place to prevent that type of fraud?
Probably not. I think we've tried to do more. I'll be candid with you. I think that there's probably more we can do administratively. We're struggling with the resources, but we are trying to do that. I think there probably are some places where we could use some more help from the Congress. So if I could get back to you on for an answer for the record on that, I think it would be a better response.
Great, thanks. Thank you, Chairman.
Thank you. Mr. Doggett.
Thank you, Mr. Chairman, and thank you, Commissioner. I have follow-up on the same two concerns that Mr. Becerra raised.
Okay.
First, with reference to your budget. The monies that finance your budget are from taxes that have already been paid and are being paid. Those taxes are not going down. It's a question of whether we provide the resources to Social Security to effectively and efficiently provide the services that a worker who has the misfortune of disability would expect. And you mentioned some goals on appeals, for example. Is it correct that currently that you do not have the resources to replace Social Security Administration employees who retire or depart to another job?
As a general matter, Mr. Doggy, yes, that's correct. We've got a hiring freeze in place with some very limited exceptions that relate to backlog reduction. And in addition, we have, and I'll give you the exact number for the record, probably slightly over 1,000 employees that basically we're waiting to see what happens with sequestration. We've gone up to the 1% statutory limit, more or less, on the retired annuitants. We've also, to the extent that we've made exceptions in the hiring over a lot of objections from some of my people, I have said the people that have been with us the longest, that's where our obligation is first. So the extent that we've done hiring in the last 6 months, it's been temporary, so that if we have a deep cut under sequestration, we will let those people go and take less out of the people that have been working for us for 20, 30 years. So we've got a large group of people who are hanging in the balance waiting to see what happens with sequestration.
And while your oral testimony referred to the significant progress you've made in reducing the backlog on the time that an appeal takes, those numbers are beginning to trend back up, aren't they? In recent months, they've gone up from the low that you talked about last October?
Slightly. I mean, I think statistically I would call it approximately level, and there is some wobble. I'm swearing in 40 judges tomorrow, and we've got some more coming. So I think that by the end of the year, there's a good chance that we'll be essentially level for most of the year.
Is it unlikely that you can meet your objective of 270 days unless your budget is fully funded?
Yes, there are a couple. So let me be totally forthcoming. I think we were making extremely good progress on the 270. There were doubters, so Congress asked GAO to do it, and they gave us a 78% probability a couple years ago of hitting it. I'll be honest with you, it's very unlikely we're going to hit the 270 on time now. And it's a combination of the recession, timely judges from OPM, and funding for staff. Right. I'm doing all I can on each of those three things, but those are the critical factors for how close we come.
Let me turn to the second concern, and that's the question of the change that was made last December, so that someone who's coming to bring an appeal can find out who the judge is.
Right.
And I've been a judge before coming to Congress, and I've also been a litigator, and it was always important to me, whether I was bringing a claim or defending a claim, to know who I would be presenting that claim to. As it relates to in-person conferences, not video conferences, is there any good reason why the practice that Social Security has followed in the past of letting someone know before they walk in the hearing room who the judge is, why that ought not to be continued?
Yes. So I think, in fact, it embodies a fairly important principle of justice. And again, I think if we had realized the extent to which random assignment was being manipulated, we would have acted sooner. And that's because when you have as much manipulation as we're concerned that we have, the consequence of that is that the 15% of the claimants who are not represented are, by definition, getting the stingiest judges. And I don't think, I mean, these tend to be the people who are the least sophisticated.
Well, if
they tend to be the people who are most impoverished, and I don't know how you can say...
If it is in fact random assignment, why can't you announce who the judge is before you walk in the room?
But, Mr. Dye, it's not random assignment. What we have discovered is that claimants' reps have found a number of ways to manipulate the system, and that the principle of random assignment has been violated in any of number of ways. This is why it's taking us so long to come up with a fix. It's not just the video hearings. It's not just the particular problem we had at Huntington and those kinds. As we've dug into this, there are a variety of problems around the system that come from non-random, random assignment being violated. And what we're trying to do is get a handle on that as best we can with a permanent solution. But in the meantime, I don't think it's fair or appropriate that the people who are, as a general matter, on the bottom end of the spectrum get the judges that are least likely to award them benefits. I just don't, I mean, we're supposed to be representing these people too. And that's what judges are supposed to do when they come into hearings. They're not supposed to be.
I hope you'll supplement the record on specifically what, if there is random assignment, specifically what has occurred that you can't resolve in some other way than denying an opportunity to find out who the judge is before you walk in the room. And on video conferences specifically, so long as there is agreement that if you agree to a video conference, you get the judge that's assigned in the video conference. What's wrong with that?
If you would allow a friendly amendment to your request, what I'd like to do is come up and brief staff, because several of these issues that have come up, which are not public, have or potentially have a law enforcement dimension to them. So I'd rather not lay that out in the record. And I'd also rather not, to the extent that we're being defrauded or the system's being abused, I'd rather not lay out publicly how it's done as a roadmap for others to do it until we can do it. So what I would like to do, and hopefully we can do this on a friendly bipartisan basis with the majority and minority staff, is come up and go through some of these other things that we've come across that have given us the basis for significant concern.
Thank you.
There's a little bit of manipulation among the law firms too that represent some of those people that they're in it for money.
I think that's more on the video, that's not on the.
Yeah, and that's why he really didn't respond on the video part.
Yeah.
If you agree to a video hearing and you get whatever judge is to be assigned at random from one of the national centers, why isn't that sufficient protection on video?
Well, because under the current rules, you're allowed to manipulate and pick and choose. You can see who you get on the video, and then you could decide to decline.
But if you're restricted and you get your only choice, you change it, and your only choice is to get the judge assigned to the video, why isn't that sufficient?
Well, we're looking exactly at doing that, but I believe that my at least interim advice from General Counsel is I need to do that through notice and comment rulemaking. The other thing, again, without compromising what's happening, the other technique, and I'm concerned also about this on some other levels from a claimant's perspective, is that a number of reps have gotten into the practice of simply withdrawing an appeal and then refiling. And that's another way in which random assignment has been manipulated in some part. And some of this is our fault. Some of this, I don't know that we've been entirely consistent even in applying our own rules. So it's a difficult problem. It's an important principle of justice to get this right. We're trying to take the time to do this right. In the interim, I think what we're doing, we acknowledge is not perfect, and we have not represented that we want to continue to do it indefinitely. I'd be delighted to go back to telling people who the judge. I think the criticism is a little bit overwrought in that, it's the same VA, NLRB. I don't believe you get notice of judge. Most workers' comp, you don't get notice. I, too, was a trial attorney in my reckless youth. In the Massachusetts Superior Court, at least in 1985, when I tried my first case, you didn't know who your trial judge was until you walked in, and then it changed on a monthly basis. So, you couldn't really design a case for the predilections of a judge because the judge would change multiple times over the course of the trial. So again, I'm not defending what we're doing, and I've been, I think, straightforward. I don't want to continue. I'd be perfectly happy to put the judge's name back on, but I don't want to do it until I fix things that are important for the integrity of the system.
Thank you, Mr. Chairman.
That was a good answer. Thank you so much. And, during your term, you've worked with 2 different administrations, and your dedication to doing the job to the best of your ability has never wavered, in my view. The American people and we are grateful for your focus on the disability program during these challenging times, and along with your achievements. Thanks for your service, your leadership. I have one final question. Based on your experience, what advice would you give your successor?
Buy a flak jacket. I think that the most important thing is to realize that you do take a lot of criticism in this job. And it's because Social Security is such an important institution in this to the public, and the expectations are very high. We're in a a world where it's going to be very hard to satisfy those expectations in the coming years. What I would urge my successor to do would be in part to urge all of you, there's several ways to try to do this better. One is to spend more money on the status quo. The other is simplification, and we've tried to do what we can from a regulatory point of view. This committee, I don't think, has ever gone systematically back through the Social Security Act and say, well, is what we made sense in 1964, 1977, 1992, does it make sense today? And it's an extraordinarily complicated act, and I think that there are opportunities where we shouldn't come any kind of partisan divide, where we can say, look, let's just make it simple. I mean, one of the things that saved us the first year we did administratively is we realized for 30 years we'd been requiring original birth certificates brought into the office or mailed to us with every retirement application. And we did not need that because we could authenticate through other more modern means. It made sense in 1965, but it did not make sense in 2007. I think there are a lot of opportunities to straighten out. This is only one small part. This is probably only about 10% of the Social Security Act right here. And I think that we can find opportunity. Maybe you should get some outside expert advice, but I think you could find a lot of ways to simplify it that would lower our administrative costs. So if you don't want to give us the money, there are other ways to do it. And I think that I actually regret that I hadn't given this speech a little bit earlier and asked you to consider doing that a little bit. And I think for the next person, I think it's going to
Modernize the system. We can do that. I forgot, Mr. Smith, I apologize. I forgot Mr. Doggett first, so you're the second one. You're recognized.
Thank you, Mr. Chairman. Thank you, Commissioner, for your service and certainly your time here today. Going back to, I think what Mr. Doggett was talking about a little bit, but I mean, my office has worked with a situation where it's our understanding that an applicant's attorney recommended the applicant request a delay of their hearing because they felt they would get a different, perhaps a more favorable hearing from a different ALJ. Obviously raises questions, and some were touched on a bit earlier, certainly about the uniformity of the system and perhaps what you could point to in addressing that uniformity. But I would say even more so when we talk about the workload, if one judge has prepared to hear a case and then ends up not doing anything with it, and then someone else has to prepare, and who knows what circumstances will surround that as well. How should we address this? What would you have to say about moving forward and perhaps the judge anonymous policy that was touched on earlier as well?
I think the thing to do is to work with us to try to get some consensus on particularly the things that we need in notice and comment rulemaking. I've been surprised at least a few times where things that looked like there was consensus and not very controversial became very controversial in the rulemaking process, and sometimes the Congress contributed to that. So I think what we're trying to do is to try to figure out as much of a consensus approach as possible. And I do want to give some credit to NOSCR, the attorneys group, because they've already come to us and put some things on the table which I think we would have thought were unlikely to try to help us to fix this problem. And I want to commend them for taking that step in the public interest. And I think if we can all work together on this to try to devise a combination of administrative and regulatory approaches to straighten this out and just get it done and get it over with as quickly as possible, then I think the world will be better off.
Okay, thank you. I yield back.
Thank you. Thank you for your testimony.
Thank you, Mr. Johnson.
We'll proceed to our second panel now. And will the witnesses please, on the second panel, take your seats.
Ted's
said my mic was popping. I didn't hear that. Was it? Is it now?
No, it was like every time you turn it
Huh.
on.
Ethel Zielinski, Director of Government Affairs, National Organization Social Security Claimants Representative on behalf of the Consortium for Citizens with Disabilities Social Security Task Force on the left, or your right. Honorable Randall Fry, President, Association of Administrative Law Judges. Welcome back. Jeffrey Lubbers, who is Professor of American University, Washington College of Law. And Richard Pierce, who is a professor at George Washington University Law School. Thank you all for being present. Ms. Zielinski, recognized. Please go ahead with your testimony.
Chairman Johnson, Ranking Member Becerra, and members of the subcommittee, thank you for inviting me to testify today on behalf of the CCD Social Security Task Force. Title II and SSI cash benefits are the means of survival for millions of individuals with severe disabilities. In the past, I represented claimants at all administrative levels and in federal court. My experience made me all too aware that behind the numbers are individuals whose lives have unraveled while waiting for decisions. I recently received an email from a gentleman who appealed to the hearing level. This is how he described the appeals process from a claimant's perspective. I just don't understand why everyone is denied 2 times and forced to wait to have a hearing. I was very prepared from the onset with my documents. SSA was sent letters from my neurosurgeon, neurologist, and 2 separate pain management doctors who I've been going to on a monthly basis for the past 8 years. Being denied was mind-numbing. We lose everything we worked for over years during the waiting process. I am currently over $100,000 in debt and have sold everything of value, including our wedding rings. My car was repossessed, and now my home of 18 years is in jeopardy. The pressures of my medical issues have caused our marriage of 18 years to collapse. I have never been a fragile man. I am educated with a university degree. I've been active in my community and even own my own small company. It's hard enough for a family or a person just to deal with an illness, but it's harder when the government can keep your life on hold while you're ill. While the wait for a hearing is still too long, processing times have been significantly reduced over the past few years, now around 350 days, dropping more than 6 months. We support the Commissioner's goal of reaching 270 days by the end of next year. However, we are deeply concerned that any progress will be stymied due to a lack of adequate resources for SSA, thus putting that goal and other critical workload benchmarks at risk. We appreciate the subcommittee's past support to provide SSA with adequate funding and urge support for the President's fiscal year 2013 request that will allow SSA to continue to move forward. Central to the fairness of the SSA appeals process is a claimant's right to a hearing before an ALJ. While ALJs have recently come under increased scrutiny, it is important to recognize several points. Favorable ALJ decisions account for only about 1 in 5 allowances, with the vast majority made by DDSs. The overall ALJ allowance rate has been dropping and is at the lowest level in years. There are many legitimate reasons why ALJs reverse DDS decisions, as detailed in my written statement. And favorable ALJ decisions are being reviewed by SSA to determine compliance with agency rules and policies, but in a manner consistent with the law, ensuring the independence of ALJs. We do not support proposals to have the government represented at hearings. The longstanding view of Congress, the Supreme Court, and SSA is that the process is informal and not adversarial. SSA had a previous pilot where the agency was represented. I represented clients at a hearing office in the pilot and can confirm Congress's findings at the time that the pilot did not achieve its purported goals. It led to longer processing times, did not improve the quality of decisions, and did not result in better prepared cases. While radically changing the process, the expense was enormous, costing more than $1 million per year in 1986 dollars for just 5 hearing offices. Today, there are more than 140 hearing offices. We support many of the Commissioner's initiatives to reduce processing times and make the process more efficient, including technological improvements such as online access to electronic claims folders and the ability to file appeals and submit evidence electronically. Also, there are a number of case screening mechanisms that expedite decisions without sacrificing accuracy. I am glad to report that the gentleman I described earlier was found eligible through one of these hearing level screening initiatives. My written statement discusses our recommendations for improving the process for people with disabilities, such as increasing the time for hearing notices and helping claimants to obtain representation earlier in the process to assist with development of the claim. We also provide recommendations to better develop claims at the initial levels so that the correct decision can be made at the earliest point possible and unnecessary appeals can be avoided. Thank you, and I will be happy to answer any questions.
Thank you, ma'am. Randall Fry, you're recognized, sir.
Thank you very much, Mr. Chairman, Ranking Member Becerra, and members of the subcommittee. Thank you very much for the opportunity to be here this afternoon to talk about some very important issues with respect to the disability adjudicatory system at the Social Security Administration. I'm president of an organization that represents 1,400 judges, and I feel like the weight of all 1,400 are on me every day because I hear from them on a regular basis, and I understand the trauma that's ongoing dealing with a rather significant backlog. You know, there are some good things, however, that's happening at the agency. Good things that result from your actions. 3 years ago, you responded favorably in a budget context and permitted the agency to appoint several hundred additional judges and staff, and we have dealt with the backlog. We have worked exceptionally hard. It's troubling to hear or to think that come January, the bottom may fall out of this progress. So I urge you on behalf of all of the American people to please do what you can to ensure that this agency is funded so we can continue with the disability backlog. While I think the judges and the staff have worked well, there's some things that haven't worked so well, and we have some ideas that we would like to share with you. What isn't or hasn't worked well, quite frankly, is that, and believe me, we understand the importance and the need for goals in everyone's life, personal and professional. Goals have driven this democracy to the highest levels. What we have been faced with as judges, however, are not goals. They've been quotas. Quotas are destructive, and they force decisions before they're ready. If you understand that process, as you most certainly do, under the present structure, judges have the responsibility of wearing 3 hats, incredible responsibilities in wearing 3 hats, representing the government or the people, representing the claimant's interests, and of course, ensuring that the law is applied correctly to a decision. That's a heck of a burden if you think about it. It requires the judge to engage in rather aggressive and vigorous examination of a claimant. Oftentimes, that puts one at loggerheads with the claimant and the claimant's rep. It almost places the judge in truly an adversarial relationship in the process. That's not a healthy judicial environment. It is not good, in my view, to have the judge wear 3 hats. It is certainly good that the record is developed. Indeed, without record development, we could not make a decision. An answer, we think, to this problem, and an answer that at long term would save money, is to have the government represented. If you think about it, and I've said this before, how many corporations or companies that you know of would go to court facing a lawsuit where the plaintiff is seeking $300,000 without representation? That's what's happening in our courtrooms. The government comes without representation. Indeed, I recognize part of my responsibility is to represent the government, but what I'm trying to communicate to you is that it is a very difficult process. It's a balance that sometimes gets skewed. We believe the advocacy of a government rep would be important, but even more important from the claimant's perspective, a government representative would be assigned the cases early in the process. The government representative would develop or ensure that development of evidence is in the record. The government representative would work with the claimant and the claimant's attorney to pay the case as early as possible without a hearing, thus saving the more expensive time for conducting a hearing and having to issue a written decision after a hearing. The government rep has a lot of value. It's the individual that would be designated in a hearing office that the attorney, on behalf of a claimant, could call and talk to about a case, to find out the status of a case. Right now, it's if you talk to many representatives, it's quite difficult to talk to anyone in a hearing office. Not because we're unfriendly, it's just that everybody is swamped with work. The problem with the quotas is particularly perplexing to, I think, any professional who has to have time to consider important and complex issues. What has happened to us is, because with all of the wonderful programs the agency's established over the last few years, the easier cases are getting addressed before hearing, or many of them are. The cases we hear are far more difficult.
Can you close? Your time has expired.
I'm sorry, I will indeed. I have other points that I made in my statement, and I would like, if at all possible, submit a statement on the APA and its applicability to our hearings at the close of hearing.
Sure.
Thank you very much.
Thank you, sir. Mr. Lubbers, you're recognized.
Thank you, Mr. Chairman, and Ms. Ranking Member Becerra for inviting me to be here today. I am Professor of Practice in Administrative Law at American University's Washington College of Law, where I've taught since 1996. As I note in my biography, from 75 to 95, I worked at the Administrative Conference of the United States, ACUS, and am now serving as a special counsel at the revived Administrative Conference. However, I want to emphasize that my views I'm expressing today are just my own, and as an administrative law professor, and should not be ascribed in any way to the Administrative Conference. The growth of the SSA Disability Adjudication Program has been phenomenal.
Is your mic on?
The growth of the SSA Disability Adjudication has been phenomenal. In 1973, the then president of the Association of ALJs reported that the number of disability proceedings reaching the hearing level had, quote, jumped to an unbelievable 56,000. That year, the per-judge disposition rate was 143 cases per year. Today, those numbers seem minuscule. Commissioner Astrew has said that he expects the caseload to reach 832,000 in fiscal year 2012, with about 1,400 ALJs. The per-judge disposition rate has more than quadrupled to 594, and this rise in caseload shows no sign of slowing down. Now, to sketch out the legal context of the program, I would mention that although SSA benefits once received are an entitlement, which means that the government cannot terminate benefits without a formal hearing, it is not so clear based on Supreme Court case law whether that level of due process applies to initial applications and denials of benefits. The Supreme Court has never held that an applicant for public benefits possesses a property interest protected by due process. Another unresolved issue is whether the formal adjudication provisions of the APA are applicable to SSA disability adjudications. While this is an interesting legal and historical question, it is one that I don't think is all that crucial to resolve, because ultimately the issue of the APA's applicability is up to Congress, and the APA itself gives both Congress and the agency a lot of flexibility. But to clarify my own answer to this question that you mentioned, I think that if you just look at the language of the Social Security Act, an APA hearing would not be mandatory. But that analysis is probably trumped by the clear message Congress and this subcommittee sent in the 1970s when it converted the temporary SSI judges into full-fledged ALJs. Now, over the years, I have urged a number of key process reform proposals that I summarized in my testimony. Many of these ideas were included in SSA's 2006 DSI reform proposal. However, other than a couple of the proposals, the rest of the DSI program was prematurely terminated, apparently due to resource constraints caused by the crush of caseload pressures that worsened after 2006. I would like to see a renewed effort to implement these process reforms. However, that may not be possible now. So I've suggested some possible options and approaches in dealing with some of these caseload pressures, some of them incremental, such as increasing the use of rulemaking, some of them and increasing the use of video communications technology, and some more fundamental. Some of the more fundamental change options might include modifying the role of the Appeals Council to increase the quality control review of grant cases and to use selected Appeals Council decisions as system-wide precedents. Second, replacing both the Appeals Council and the District Court stages with a Social Security Court. Third, making SSA hearings adversarial, although I'm not convinced that that would be cost beneficial. And fourth, taking advantage of the APA provision that allows specially designated administrative judges even in APA hearings. Now, this last option requires a bit more explanation. If Congress does become persuaded that circumstances require that hiring more ALJs is no longer a tenable answer, Congress could specially provide for or designate another type of adjudicator under the APA. Congress has done this occasionally. A prime example is the special authority given to the Nuclear Regulatory Commission to use Atomic Safety and Licensing Board panel members to hear nuclear licensing cases. In those cases, Congress wanted to provide the agency with the flexibility to not only use law-trained judges to hear licensing cases, but also scientists. Now, some have suggested using doctors as adjudicators. I'm not sure that's a good idea, but I do think that there are enough problems with the ALJ program to perhaps lead Congress to suggest that there's a need for a specially tailored SSA ALJ program. And in doing that, Congress could allow SSA to basically hire its own judges using the OPM process. They've done that with the NRC and with boards of contract appeals. Congress could also consider departing from the current ban on performance appraisals for ALJs. I know there are arguments on the other side of that issue. So there are a number of things that Congress could do if they specially designated Social Security ALJs. My overall point here is that the SSA's ALJ program size and perhaps the character of its cases may now require some special treatment. By providing the menu in my testimony with some commentary along the way, I hope I can assist this committee in performing its historical role in protecting the viability of this historic program.
Thank you, sir. Mr. Pierce, you're welcome aboard. Go ahead.
Chairman Johnson and Ranking Minority Member Becerra and other members of the committee, thank you for giving me the opportunity to share my views on this important topic. To me, there are two major problems at present with the Social Security disability program. One is that it is increasingly and unsustainably generous. The proportion of the population that has been determined to be disabled has doubled. The cost of the program has more than quadrupled. And that is primarily due to ALJ grants after 2 denials by state agencies. The other problem is related to that. There's massive variation in the ALJ grant rates. The latest numbers I've seen were 8.6% grant rate for one judge, 99.7% for another judge. This is a problem that has been extremely well documented for over 35 years. A book written by 6 researchers in 1978, concluded that the identity of the judge is far more important than the facts of a case in determining the outcome of a case. If you don't address that problem in some way, 35 years from now, someone else is going to be telling you that it still exists. I think there are 3 sources of the problem. First of all, well, let me back up and say that one of the reasons this is so difficult is most of the cases that are the subject of dual denials at the state level and then grants at the ALJ level involve one of 2 disabilities: mental disease and pain. And the National Institute of Medicine and the National Institute of Mental Health tell us that over half the population suffers from one of those conditions. Obviously, we cannot have a situation in which over half of the population is qualified as permanently disabled. What judges have to do, and it's difficult for any decision maker, judge or not, is to figure out whether someone is so severely mentally ill or so severely subject to chronic pain that they're not able to work. And when you look at the variation in the ALJ grant rates, and you look at the overall increase in the grant rates over time, it's quite obvious that while some judges are continuing to grant disability only to those with severe mental illness or severe pain, some now grant them routinely to people with minor mental illness and minor chronic pain. And by the way, I fit in both categories, so I suppose I should have applied a while back. The sources of the problem are three. First of all, that the administrative law judges cannot be subjected to any process of evaluation or system of quality control. You're in a position to correct that problem, and I hope you will. The second is that this whole system of decision-making was designed to operate without lawyers. Well, today, 85% of the applicants are represented by lawyers or other professional representatives. This has changed the nature of the process dramatically and certainly is a contributor both to the wide variation in grant rates and to the increase in the number of people who are determined to be disabled. Something needs to be done about that. What I think you need to do, I would urge you to do, is reduce the extremely generous fees that are now available that, as I read a report the other day, amounted to $1.5 billion last year, and change the method of calculating the fees to eliminate this problem of a major economic incentive to delay cases. The third source is, frankly, the courts. The courts pay no attention to what you say in your statutes about scope of review. I have in my testimony citations to studies that show the courts absolutely do not pay any attention. What I would urge, at least initially there, is that the Social Security Administration start taking more cases to the United States Supreme Court. It has shown over the years far more respect for your views about scope of review than have the district courts and the circuit courts. It may take 2 or 3 cases, but I think that's what has to be done. To help that along, I'm going to file a petition for rulemaking at SSA next week to urge them to take an action that most certainly will get them into court, and I hope the United States Supreme Court that will then get the lower courts back doing what you have told them to do. Thank you.
Thank you, sir. I appreciate that. Judge Fry, the agency's published its expectations to do 500 to 700 cases a year. In your testimony, you say the current misplaced emphasis on numbers has perverted our system of justice. So are you saying there should be no expectations, that judges should take as much time as they like while claimants wait in line?
Absolutely not. As I indicated earlier, I strongly believe in goals. But the better standard is a wider range. If you just do the numbers, you're thinking, if you can look at a paper file of 600 pages of medical evidence, do you want a judge to spend 2 hours on that, or do you want a judge to spend whatever time he or she needs to understand the case? That's the problem with, you got to do 500, you got to do 700. Judges work hard. They're working, to do those numbers, they're working 7 days a week. I get emails every week complaining and asking for some help. So no, we're working hard, we believe in goals, and judges are responding to goals. Most professionals don't work well with unreasonable quotas.
How many did you do last year?
I don't know. I have I am 90% on official time, but I honestly don't know. Probably somewhere around 50 to 100.
Okay. Well, I was in the office in Dallas, and I can tell you that one judge out of 12 was working. Normal day. I understand one of the ALJ union vice presidents in the Buffalo hearing office told judges not to process more than 300 cases a year. Is the union pushing that?
I've never heard that statement, and I honestly find it incredible.
Thank you. And earlier this year, after the Inspector General reported that claimants or their representatives were declining video hearings so the case would be assigned to a judge who allowed more cases, Social Security is now not identifying the ALJ until the day of the hearing. You think that's right or wrong?
I think all of our hearings should be transparent, should be open to the public. I think our notice of hearing should clearly set forth all of the issues for the hearing, including the judge's name. The government can't do its business in secret.
I hear you. And Ms. Zielinski, do you know why claimant representatives would cancel hearings for their clients who had been waiting months to see a judge?
I mean, there may remember to turn my mic on. There are many legitimate reasons why people ask for a continuance, if that's what you're asking. I mean, the claimant may be ill and unable to travel to the hearing that day. I mean, that's usually the most typical reason that people ask for a continuance of the hearing. I mean, from the reports we get from our members, it wouldn't normally be because the evidence.
Well, what percentage of them are done by TV nowadays? Do you know? Any of you?
SSA has that information, I think. I think it may be around 5%, but.
Oh, is that all?
I could be wrong.
Boy, they've got it rigged for more than that. Professor Lovers, with a program this large and this complex, does it make sense that Social Security can't oversee the performance of judges for consistency? And are there any other programs that you know of that do it right?
I think, and I've written on this government-wide, that I think that administrative law judges should be subject to some sorts of performance appraisal in a peer review way conducted by the chief judges at the agencies, and that doing that properly would not infringe on their independence. And I think in this particular program, where the caseload pressures are so great and efficiency is such an important value, I think there's even a stronger reason to do it in the Social Security Administration program.
Thank you. Mr. Passero, you're recognized.
Chairman, thank you, and to the witnesses, thank you very much for your testimony. Judge Fry, I want to ask you about some of your comments about the current informal process that's used. I have deep concern with what you said about moving towards an adversarial system. Let me tell you why. We just heard the commissioner tell us that he's got a very tight budget, a budget that doesn't allow him to do everything he needs to do, which is putting a greater load on many of your fellow judges. Where would we get the money to pay for the new now government attorneys that you would want to have conduct these adversarial hearings, where now you'd have a more formal presentation of documents? And it seems to me that not only do you increase the cost of going through that administrative appeals process now, but you probably prolong it to the point of maybe having appeals to the appeals hearing, to the different stages going up to the federal courts, in which case now Social Security is now having to pay for representation at the court level, federal court level as well. I would think that we would want to recognize that, one, we're talking about typically the poorest folks in America, who are the sickest, probably the frailest, who probably don't have a lot of money to hire really high-powered attorneys. Maybe hire an attorney, but we're not talking about hiring, the Jones & Jones law firm. My sense is that it would be better to give you quite a bit of power to conduct the informal hearing, to try to extract as much information as you can from the individual or his or her representative, and therefore you feel comfortable that you can go at that individual, if you have to go at them pretty harshly, or treat them with a little bit more care because they may be very ill, in which case what you're trying to do is extract the information as best you can so you can come out with a decision. Ultimately, that individual still can go above you if he or she is not satisfied with your decision, but at least what we do is give you quite a bit of discretion to try to come up with a good decision. And then, of course, deal with the outlier judges who are granting too many or too few.
I could give you so many different answers to each of the points you make. I think, however, with respect to government representation and the cost, there would be so much savings from the appeals of cases at the higher range. It was mentioned earlier, 99%. I suspect you would save billions ultimately. Now, there's another built-in savings.
Do me a favor, send me whatever you can to corroborate what you've just said about the billions in savings.
We'll do the math.
Okay.
And I'd be most happy to.
Okay.
The other savings, quite frankly, and it's a huge savings, we are one of the, my background is with the National Labor Relations Board, and I well know the regional office structure there and how they function. This agency also has a regional office function, the district offices, but in addition, we have ODAR, the Office of Disability Adjudication, having regional offices that perform no direct case adjudications. These are very expensive. They're in the most expensive cities in the government, occupying the most expensive space. That's maybe 30 years ago, that layer of management, that layer of bureaucracy was okay. I don't think we can afford it anymore. Those resources should be in direct case handling.
And now you're going into a little bit beyond what I asked, but fair. I think anything that you can tell us that will help us reduce costs, we'd love to hear it. I'm concerned about moving what is an informal hearing process into a very formal adversarial process. And Ms. Zielinski, let me see if I can ask you the same question, because you represent, or your organization helps represent, a lot of the claimants that go before the Social Security agency for these benefits, disability benefit hearings. What's your opinion about moving from an informal, non-adversarial hearing process to a more formal adversarial process where you would have attorneys on each side going at it with in front of a judge?
I mean, I did have experience with that in the pilot in the mid-1980s, and it didn't really work out the way it was intended to. I mean, it was cases weren't allowed more, and they weren't better developed, which I think was one of the bigger issues about it. If you think about it, the claimants going into a hearing are asked very personal questions about their lives and what's going on in their lives. And I think you want to keep it as informal as possible. It's still nerve-wracking for them when they go into a hearing. It's their day in court. It's their day dealing with the government, and you want to try to keep it informal. I mean, I have to say that from my experience, and when I did hearings, and most of the ALJs weren't adversarial with the claimants. They were trying to elicit the information or have the representative help get the information out that's necessary to make the determination to see if they're eligible under the statutory definition of disability. And I think that's why you don't want to turn it into an adversarial process.
Mr. Chairman, thank you very much. And thank you all for your testimony. Please, any information you can provide us to help guide us, we would very much appreciate it.
Mr. Marchant, you're recognized.
Thank you, Mr. Chairman. Mr. Pierce, can you explain to this member of the committee the disincentive or the incentive for a lawyer that takes a disability case to resolve the case quickly as opposed to over a period of a year or two?
As I understand it, there's no incentive to resolve it quickly. There is the opposite incentive, because the fee is dependent on the amount of the past benefits that are awarded. And so there's a natural incentive to delay as long as possible in order to maximize the potential fee.
So it's just a pretty simple math equation for most of the lawyers.
That's my understanding. Perhaps Professor Lubbers has looked at it in more detail than I have.
No, but I think Commissioner Astru reaffirmed that position when he talked about the fact that most claimants' representatives didn't do this, but that some minority did.
And Judge, what was the average age, or what is the average age of a case once you sit down and begin to focus on it? What's the time that has elapsed from the time the person called the state, made the claim, and from that date, and then what's the average time of the mature claim once they get to the appeal process?
Of course, it varies depending on office staffing and so forth, but the typical case that I have been hearing is somewhere close to 2 years old from the time it was filed. And what typically happens once the process, the state agencies process the case and they come to the hearing level, usually that's when the attorneys get involved and far more development is done at that point. And I think that's also a reason that you see judges' decisions that disagree with some of the DES. It's not because they made a bad decision, it's just that there's more evidence at the time the hearing is conducted. But I think in most cases, I think you're looking at 2 years by the time you file the application.
So that person either has a support system in place. Do the lawyers, are the claimants allowed to advance fees, advance expenses to the claimants?
No. They may in certain circumstances, such as I know some lawyers will assist the claimant in getting an examination by a medical doctor, for an example.
Okay.
But I don't know about any direct payments to a claimant.
Is it legal or illegal?
That's a very good question. I've never had it come up before.
That's a very common practice in other parts of the law. I just wondered if it had pervaded this element because
I
you're
have not
beginning
heard
to
of
talk
that.
about what would be the claim amount at 2 years?
What would be the attorney's fee at 2 years?
No, the claim, the amount of money that. Yes.
Well, it would depend on the earnings, of course, of the claimant. It would be the monthly benefit times whatever number of months back benefits would be payable. So there could be a lump sum payment of $10,000. I've had as high as $30,000, $40,000.
Okay, so we're talking in the 10 to 40,000
Right.
range usually. So there's not. That's not enough of a financial incentive for a lawyer to go out and advance living expenses to someone while their case was developing.
I'm not sure I can answer that. I don't know. It wouldn't be for me, but I'm not sure. I couldn't answer for all lawyers.
Do any of you know of any situations where that's the case?
I don't think attorneys would be allowed to advance, I guess what you're talking about is sort of the cost, the benefits, the possible benefits. I mean, what does happen, and my practice was with legal services, so I never charged claimants fees. And what we would do, and I think attorneys do that now, is there's an agreement if you're going to get an independent examination or you have to pay for medical records, you have an agreement with the claimant that if they win the claim that they'll pay you back. I mean, we would do that even at my legal aid office, where we didn't have a lot of money, but we wanted to get that examination. But I don't think you would be allowed to advance living costs like you described.
So most lawyers that appear before you, Judge, are they single practitioners? Are they in law firms that advertise on Sunday night late, that have hats on? What kind of a law firm?
All of the above. I think typically it's a boutique, small law firm. There are a number of solo practitioners, but usually a small firm of 3 to 4 to 5 individuals. Oftentimes it's combined with workers' comp practice,
Okay.
because they kind of overlap to some extent. For the most part, they are highly skilled and competent attorneys who appear before in our cases.
Well, I have a sister that I assisted through this process years ago, and I found that to be the case. It was a sole practitioner. This was his practice. He certainly could not have become rich off of this process, and seemed sincere in trying to get it resolved as quickly as possible. Yet it took 2 years, and it was finally resolved. And a big part of our casework still in our district offices is this, referring
sure.
people and assisting people in after they've been turned down. So thank you, Mr. Chairman.
Thank you. Professor Lubbers, it's my understanding that the district courts should uphold the agency decision if there's evidence in the file that supports the decision. Do you believe magistrate justices are applying that standard of review?
Well, the APA standard is that if there is substantial evidence to support the agency's decision, it should be upheld, the substantial evidence test. And I think the statistics show that in the Social Security caseload area, the district courts are either remanding or reversing at a much higher rate than in other programs. So why that is, many of these cases do go to the magistrate judges first and then to the Social Security judge. Professor Pierce made some comments about the courts not upholding the statutory standard. It may be that these judges don't see that many cases individually, so they feel sorry for the claimants in those cases.
Is that right?
But I think the statistics do show that they do not affirm the agency as often as courts do under other programs.
How much fraud do you reckon is in the system? You got any estimate at all?
I think you
I've
should ask
seen
the
some of
IG.
it.
I think you should ask the IG on that.
Yeah, the IG's into it. What's the role of the appeals council in setting procedural decisions or establishing quality control?
Well, as I understand it, the appeals council does mostly hears cases where the claimant has been denied and makes an appeal to the appeals council. But in a small number of cases, very small number of cases, the appeals council does review granted cases just for quality control purposes. But because of their caseload in the denied cases, they can't do much of that. So I would like to see them do more of that. And I would also like to see them write some decisions that would be used as precedent decisions, and that those precedent decisions would be circulated throughout the administrative law judge corps.
So all the judges could follow?
Follow it,
Yeah.
would be supposed to follow it. And that's, for example, the way, not that this is the greatest comparison, but the Board of Immigration Appeals does have certain decisions that they make precedential and are supposed to be followed by the immigration judges.
Professor Pierce, how is the Social Security supposed to balance the fact that ALJ decisions should not be interfered with, as the Administrative Procedure Act requires, with ensuring consistent outcomes and productivity needed to administer this national program?
Well, I'd start by saying that I certainly don't think that anybody in the Social Security Administration should attempt to influence the outcome of any individual case. But it's pretty easy to do what, for instance, the vast majority of law schools do to their law professors and say that your grades have to be in a particular range. And it's pretty easy to conform to those norms. And if the alternative is what we now have, an 8.6% probability of a yes before one judge and a 99.7% probability before another. I don't think there's any question that due process and equal protection of law would be served very well by establishing some boundaries within which we expect judges to have grant rates.
Yeah, I appreciate that comment. Thank you. Mr. Becerra, you have another question?
Yeah, a couple questions. And I want to make sure I dispel any notion that there aren't, the judges, Judge Fry, don't have some template that you get to use. We have the federal district court decisions that have been handed down that give you some guidance. My understanding is the Social Security Administration also tries to provide you with a template where there's screens where you all can sort of go through some threshold questions to, that you have to answer yourself through these hearings to figure out if the claimant has answered those adequately to be able to get to the point of saying yes or no that they should be entitled to benefits. And so it's, I think the point that Mr. Lubber makes, which is I think is a good one, is to try to standardize this more so that judges aren't left to their own devices, and I think Mr. Pierce is going to that as well. So you have some way of evaluating when a judge does or doesn't grant these benefits. But I want to stress something, and I think it came out in some of the earlier testimony. We're not talking about rich folks. And even if these folks win these benefits, we're not talking about them getting millions of dollars, as you mentioned. Maybe $10,000 a year, and maybe because they didn't get the benefits for the longest time because the process took a year or two to finish, they're getting $20,000. But most of that's money that they probably have to use to pay back family and friends and others that they borrowed money to provide for their subsistence while they've been waiting to see if the Social Security Administration would grant their disability claim. The reason I point that out is because I fear that we're going to start to treat this the way we treat the regular legal system, where we have attorneys going at it, and you figure you better get the higher priced attorney who does this all the time, and you better be prepared to go at them really hard because you want to win your case. This is not the case where you're going to come down with a six-figure judgment. This is very basic benefits, and the folks we're talking about are the frailest of the frail. And I asked staff to get me some information on the whole process itself, and this is from the Social Security Administration, where they go through and give this is 2011's disability workload, so they can't give us 2012 because it's still ongoing, but 2011 disability workload. Okay, so at the initial level, how many people submit an application for disability benefits? 3,295,806 disability decisions were issued by the Social Security Administration in 2011. How many of those decisions were to allow benefits? 34%. 2/3, 66%, were to disallow at that initial stage. So right away, 2/3 of all those applicants were denied benefits. Of those 2/3 that are denied, some of them say, okay, you denied, that's it. Many of them, though, will say, wait a minute, I think you made the wrong decision, I want you to reconsider. And so they go to the next level of appeal, which is in many cases reconsideration. Not every jurisdiction has that interim level of reconsideration, okay? Appeals to reconsideration. How many of those appeals to reconsideration did the Social Security Administration receive? 853,142. They issued 819,710 decisions. Of the 819,710 decisions on reconsideration, how many of those were to grant benefits at that stage now? 12%. 88% of those individuals who sought benefits after that initial rejection at the second level, how many of those at the second level of the 819,000 decisions, how many were allowed? Only 12%. So now you have that 88% that's denied. They say, wait a minute, we still think you're wrong. What can I do to appeal that? Now you go to that ALJ. This is now at the administrative appeal level. So now you're at that third level where you're constantly narrowing down the universe of folks who are appealing. And by the way, you're now probably getting to the more complicated cases where it's not a simple clear fact of whether you get the benefits or not. At the administrative judge level, hearing level, 662,765 cases were decided. How many were allowed? 58% of those cases were allowed, 13% were dismissed, 29% were denied. There's still two other levels of appeal, a so-called appeals council, which is much smaller, only 103,000 and so decisions. Only 2% of the individuals got allowance of benefits. And then, of course, you go to the federal court from there, where the allowance rate for 13,271 decisions was 3%. My point here is to say this. There are different steps along the way, and every time you narrow the number of folks who are appealing, it's because the cases are probably more complicated, more severe, and so you've got a lot of work, Judge Fry, to do, because you're dealing with folks who, after 2 stages of being told no, they still believe yes, and so you're making some really important decisions. That's why some of us believe you should be able to be aggressive through an informal process where you can do all the questioning, as Ms. Zelensky mentioned, of that individual, the personal questions. Try to make it as easy as possible for SSA to come out with a decision. But it's a tough process, and I hope we recognize that we're dealing with folks who are, for the most part, very poor and very frail. But we appreciate your testimony, and anything you can do to help enlighten us on how to move forward, we would appreciate. And Mr. Chairman, it's been a great hearing, as have been the previous hearings on this matter. With that, I yield back.
Thank you. I'd like to ask unanimous consent to enter into the record a report by the Congressional Research Service, which provides an overview of administrative judges and how they differ from ALJs and some examples of how administrative judges are used by other agencies. Everybody's received a copy of that. Without objection, so ordered. Again, I want to thank you all for being here today and for your testimony. I look forward to continuing this discussion on ways to secure the future of this important program at our next hearing. And, you know, Social Security is a vital part of this nation, so we need to protect it. And I thank you all for being here. With that, the committee stands adjourned. Thank you very much.
Thank you.
I think so too.
Good job. Good seeing you too.